Good day, beautiful people. In the last video, I realized that I did not have this little image in there where it talks about general and special verdicts defined. So you can see here is where it talks about general and special verdicts defined. Again, the jury pronounced generally upon all or any issues either in favor of the plaintiff or defendant. They, basically decide the facts in the law. And then a special verdict is one where they only find the facts and they leave the judgment to the court or the judge, if you wish to call the judge the court. Now, moving forward, we will be talking about actions upon official bonds. So, most officials of the state, including judges and high clerks, must have official bonds for their position in case they do any damage or harm to the public. As you can see, action against Superior Court clerk. Action against the sheriff. Here is a statute from the same code book. An action upon the official bond of any public officer. Statute runs from breach of the bond, where a sheriff in a claim and delivery proceeding return the property to the defendant without taking the bond required by law. It is a breach of the sheriff's official bond, and the statute of limitations begins to run from the breach and not from the termination of the action for claim and delivery. An action upon an official bond may be brought within 6 years after a breach thereof. The statute does not begin to run from the date of the bond, but only from the breach. And so this is where they're actually codifying some of the things, and here are some of the case laws for when they breach their official duties. Unlawful sell. When a sheriff unlawfully sells property exempt from sale under execution, it is a breach of his bond. The statute runs from the date of the unlawful sale, and the action is barred in 6 years. So these are all statutes of limitations upon the bond, and they're all codified, and we're going to talk about that before the end of the video. This comes from subsection 267, and under 2, contract, express or implied. An action, official bonds. A complaint can join causes of action against an officer upon 2 official bonds, given for separate terms of office against him and the sureties common to the 2 bonds, which basically means that you can use a bond from 1 term of office, and if they're in office again for another term, you can also join those bonds. This section has to do with joinder, and that's joining 2 causes together, or joinder as in their official capacity along with their personal capacity. A complaint which are joined 2 causes of action, one upon a clerk's bond and another upon an administrator's bond, is demurrable. And a demur basically means we agree with all of your facts and it's an issue of law. Here's another case law. Suit upon 2 official bonds and 1 action. Nor is a complaint demurrable because the action is brought upon 2 official bonds given by the same officer against the principal and such of the sureties as are common to both bonds, nor because action is brought against 1 surety on such bond without joining others. Here's another case law on the liability of the clerk. And this case law talks about where the clerk fails to file a judgment for the plaintiff and the plaintiff loses his property he was entitled to through the judgment, held that the failure of the clerk under the circumstances to docket the judgment was such a breach of official duty as to render his surety on his official bond liability for any loss resulting to the plaintiff therefrom. The clerk is also liable for failure to index the judgment. So whenever they don't index the judgment or properly put it on the judgment roll, they are completely liable to the public for their official bond. And in my opinion, they should also be liable for when they file or index a false judgment as well. This is at the beginning of the book, and this is where they're talking about one form of action, and it's a civil action, so they say effect. The remedy for the enforcement of all kinds of contracts is now a civil action, not an act common law action. Under the present procedure, it is not necessary for the owner of property wrongfully seized and sold by a sheriff to first obtain a judgment against the sheriff and then institute another action on his indemnifying bond. And so basically this is kind of the most important part in my opinion, is because at common law what would have happened is that you would have taken the sheriff to court in an at common law action, and when you got a judgment against the sheriff in a court of law, you would have taken that judgment and had to have gone to the administrative side of the court to get the indemnity to pay out on the bond. That would have been fairly easy, but it would have just been a little bit more work. And what they're saying here is that in a civil action, now that they have abolished actions at law and suits and equity, now that those are abolished, they're only moving in an administrative procedure in what they advertise to the public as courts of law, but they are really not. And if the public wishes to get a court of law back, then they're going to have to stand up to the legislatures, stand up to the state governments, and require that they have a court of law and not the administrative process procedures that they have going on in the courts today. Anyways, this was just kind of a history lesson to show how things used to be as opposed to how they are today. I hope everybody enjoyed it. Please like and share these videos along with the other videos on my page or on my YouTube channel. Thank you, everyone. I am Just Conspiracy, and I just wish to conspire with other good people of this planet to leave a better world for future generations than the world we all grew up in. Just so that the public knows and understands, states still require public officials to have a surety bond. This is suretybonds.com, and they sell surety bonds to public officials because they could cause harm, injury, or loss to persons or property while they are holding their office. So this is just an example for everybody that this is still going on. They still have surety bonds. These people are still insured by some type of indemnity bond, like court clerks, judges, mayors, sheriffs, tax collectors, treasurers, deputies, constables. Explain how it works down here with the principal, the obligee, and the surety. Although insurance companies frequently underwrite public official bonds, it's important to remember that surety bonds aren't insurance. They are a form of credit. Any claim paid on a bond will have to be repaid by the offending official. The insurance underwriter will not simply assume the loss, as the case with most other forms of insurance. So whenever they have a bond, they have to pay that back. Whenever they have insurance, the insurance will cover it.
It was my introduction to a culture that has abandoned justice. I teach law school and I speak to young law students all the time, students just entering law school, and I like to ask them, why are you coming to law school? And they raise their hand with idealistic answers like, I believe in justice, I want to help the community, to make the world a better place. And I then go on to share with them one of my favorite quotes from an unnamed law student. The first thing I lost in law school was the reason why I came. I tell them, you're about to start a first-year curriculum where you are going to learn the law is about rules and doctrine. It's reduced to black letters on a white page. You will soon forget there are people behind these cases. The law teaches you that we have to think but not feel. The legal profession devalues humanity. As lawyers, we are expected to perpetuate a cold, uncaring, process-driven system, and that starts in law school.
I believe it is very important for people to like and share and get the general public knowing about law and what their rights are and how it used to be performed and why it is the way it is today. I'll be coming out with more videos, but Trial by Jury at Common Law goes into very good history of how trial by juries used to be performed, how to break down simple words in court. This is incredibly important because courts always operate from the etymological meaning of the word. Even if you go into Black's Law Dictionary and other legal dictionaries, they're usually using the etymological meaning of the word. Josephine's Confessions of a Pre-Planned Theft. This is just showing how the court system literally helps the wrongdoer and does not help people who do the right thing, even when they know what's going on. A lot of these videos have to do with Henry Ramo. If it was not for Henry Ramo, I would not have started making videos again, since I made Statute from Statue, Soulful Warfare, which this says 2 years ago, but it was almost 3 years ago. It will be 3 years in October. But I have been helping people in real life situations, and the court has not been acting completely lawless. Some of these other ones, What Are Your Persons from a Legal Standing, I highly recommend. U.S. Government, What You Are Not Being Told, How to Fire Your Representatives and Claim Your Rights, Vote the Government Out of Office. This has to do with John Locke's book, The Second Treatise of Government, which is what our Constitution was mainly written about. So there are some really good videos in here. This is a video that is one of my personal favorites, but not a lot of people watch. And it's What Will the Future Look Like? You Tell Me. And it goes through the technology that we have. And I was actually thinking about redoing this because of artificial intelligence and what's going on in society today. And we have a lot better technology and science today than we did 3 years ago when I made that. Another one that's incredibly important for people to watch, in my opinion, is What Do Senators Know Compared to the Legal Society? How the courts get jurisdiction of the body, statutes versus common law and attorneys' obligations. And yeah, just these are some basic videos. They don't go real in-depth into law, but they give people a basic general idea of what law is and how it is to be performed. Chapter 5, verse 20. Woe unto them that call evil good and good evil, that put darkness before light and light for darkness, that put bitter for sweet and sweet for bitter. Thank you for watching the video, and please stay with us. there is more to come.
The state of North Carolina helped Josephine Coker Ramo rob me of my property.
State of North Carolina allowed Josephine Ramo to rob me of my property.
The state of North Carolina allowed Josephine Ramo to rob me of my property.
The state of North Carolina helped Josephine Ramo rob me of my property.
If you wish for the judiciary of this country to stand up for your rights again, if you wish that the legislature act appropriately and not write laws that protect police officers and judicial officials and other people who are actively on the streets taking away those rights that you have, if you wish to have the right to have private wrongs redressed in a court of law and not a civil court of administrative procedure, then please help us out. I am Just Conspiracy, and I just wish to conspire with other good people of this planet to leave a better world for future generations than the world we all grew up in. Thank you.